policy on IPR. We should be assisting our students as our faculty members to file the patents, copyrights, and this awareness is regularly increasing. I'm thankful to Rajiv Gandhi National Institute of Intellectual Property Management that they have actually holded our hands in this area, and hopefully all the participants will be getting a lot of the information, and they will be well versed with how to go about these patents and this IPR regime. And I am congratulating all the organizer, Dr. Gurpreet, Madam Pratibha, Madam Agrim, and all other organizers who have made this webinar possible. Hopefully, we will be having more program of this way, because creating awareness require regular exercises, regular awareness sessions. And thank you to the speaker for sparing the time with us. Sir, SD College Chandigarh is a college with potential for excellence, having NAAC plus status. It is duly recognized by NIRF also, having very high ratings by India Today, Outlook, Week, and such credential number of. But one area which I feel we can improve is the area of research and IPRs in particular. Your session will be a gainful experience for all of us. Thank you, and thank you for joining. And I hope that all of us will have an interactive session and will get a lot of knowledge information from the speaker. Thank you.
Thank you, sir. And with this, I wish to introduce the resource person for the day, Shri Kumar Raju. Presently, he is the Assistant Controller, Patents and Designs, Indian Patent Office, Mumbai. He started his career as an examiner of patents and designs at the Indian Patent Office, Delhi, under the Ministry of Commerce and Industry. His job responsibility then included examining the patents filed by both Indian and foreign applicants. Henceforth, he was promoted to being the Assistant Controller of Patents and Designs at the Indian Patent Office, Delhi, wherein his job responsibility included granting a patent filed by an individual or a company including both Indian and foreign applicants. He also happens to be the alumnus of the prestigious Indian Institute of Technology, Delhi, and it is a pleasure to have you amongst us today. Moreover, proceeding towards the session, the participants are requested to note that your queries will be taken up by the end of the session.
फेसबुक पे देखी थी सर ने डाली इसको ऑफिस क्या बोलते हैं एनएसएस वाले लड़के प्रिंसिपल और वो सब थे ना अच्छा अब इसका क्या करोगे?
The participants are requested to note that your queries will be taken up by the end of the session, and also the link to feedback form will be shared by the end of the session, and awarding of certificate of participation will be subject to filling the feedback form. Proceeding further to the session, I now request Shri Kumar Raju. Sir, the stage is all yours now.
Okay, ma'am, good morning. And I welcome you all on the behalf of RJ and IPM. And I also want to welcome you all personally for the today's session. And I request all of you to get maximum from this webinar, because this is for you, not for me. So note down your queries, note down your, if you have any further inquisition, if you have any further any information, you please note it down and let me know after the session. Okay. So first of all, I want to share my screen. So is my screen is visible to all?
Yes, it is visible, sir.
My voice is also clear, so we can start. Okay.
Absolutely, sir.
So, yes. So it is the program named as National Intellectual Property Awareness Mission, named as NIPAM. So there are so many words which has to be pay attention from the starting point. First of all, what is this intellectual property and what is this awareness mission? So I want to start you with some data. These are the statistical data. that in India the patent filing is only 60,000. Okay. In comparison to us, China has the filing of 15 lakhs. United States has the filing of 6 lakhs. Japan has the filing of 3 lakhs. Okay. So the thing is that out of this 60,000 filing, the contribution from the organization and the institutes is only 6% as per the WIPO report, World Intellectual Property Organization report. It is only 6%. So there is a 94% of opportunity for the organization and the institutes. First thing. Second thing is that it has been understood that there might be so many reasons that we are very, very far behind in terms of intellectual property filing. Since we are in terms of population, we are next to the China. So, and we know that we have very intellectual brain, very hardworking person, very good R&D labs. So where is the problem? So it has been understood by the government that there might be certain problem with the awareness. People don't know what is patent, how it can be filed, what are the benefits, what can be patented, what can be some certain intellectual property. So that's why this mission has been started to aware most of the person so that they at least know what is intellectual property. Okay. So this was the statistical data. Now come to the definition. What is the definition of intellectual property? There is an organization named as World Intellectual Property Organization who has defined intellectual property as it refers to completely creation of mind. Okay, such as inventions, literary and artistic work, designs, symbols, names, images used in commerce. So, first of all, when it refers to creation of mind, okay, so creation of mind means when your intelligent mind, when your knowledgeful mind combines with your experience, your more and more information, more and more brainstorming, and how you can practically execute your thinking. That all comes under the creation of mind. Okay, and what are the outcomes of the creation of mind? It may be as an invention, and for invention you can file a patent. For literary and artistic work, you can file copyright. For any article, you can file design registration, and for any symbols, names, images used in commerce, you can file trademark. Okay, so these are the common intellectual properties, and we cannot limit into a certain boundaries only. Okay, and accept copyright, everything other intellectual properties are industrial property. Industrial property means they can be used in industry, they can be made in industry. Okay. Now, when we go behind 30 or 40 years back, there was very, very much importance of the physical property, such as land, plots, vehicles, all have very good honor at that time. Of course, it has the value also this time, but now these are something, sometimes it is going to become an essential things. Now the most now everything is coming into the intellectual property. Now today's scenario is about intellectual property. We are completely surrounded by the intellectual property. Anybody, any place we can see. You have the number of so many participants are there. All have pens. All pens have the same technical feature of writing, but the design of each and so many pens are different purse you have. Okay, different laptops, mobiles, whatever you are connected, all things are different. So these are the another design aspect. These are again another intellectual property. So today's scenario is completely about the intellectual property. Okay, so these are the certain differences between the physical property and intellectual property. You know something about that. So you know about what is property. Property means something for which you have a legal right. Without legal right, anything cannot become your property. So like the physical property, intellectual property, you have to also take the legal right. And who will give the legal right? So a statutory body or a state, that they will only give you the legal right. Means in that case, Government of India can also give you the can only give you the intellectual property right. No state government has the right to give the intellectual property. Okay. So now it is, first thing is that it is intangible asset, it is tangible asset. Okay. See, the important point is the transfer cost. In terms of intellectual property, transfer cost is very hard to calibrate. Okay. And in terms of physical property, it is very easier to calibrate, because if you have certain invention in your hand, so you are the whole and sole person to determine the cost of your intelligence for the licensing and for the assigning to the some other person. But in the case of physical property, the rate is decided by the society, rate is decided by the market. You cannot have the whole and sole authority on that in deciding the rate. Okay. And intellectual property is, of course, it is for the limited period of time, and physical property is for the unlimited period of time. It means it will move from one generation to another generation for the physical asset. But the intellectual property, there is limitation of time, such as patent is given for 20 years, trademark is given for 10 years, it can be extendable up to 10 years more, copyright is given for the 15 years. So each and everything, and even it depends on the from country to country. So I am telling about the India. And enforcement of property rights is very relatively difficult, and it is very relatively easier, because you have to go to the court for the intellectual property right, and in terms of the physical property, it is relatively easy. Now the thing is that, suppose that a common person, if he gets the patent, what he will do with that? So he will get some promotion in his institutes, or he or she might get some promotions, some incentives. Okay, he can get any data, or he or she might get some social value. On the other hand, commercialization means licensing or assigning. Okay, so the thing is that, suppose that you know that what a commercial person will do, he will assign his right, he will license his right to make more and more money. Okay, he can make some trademark logo, that this is my invention. So suppose that Apple is there, Apple laptop is there, he made that Apple logo for the trademark. So if anybody can look that logo, he can understand that okay, it is Apple laptop, it is Apple mobile, it is Apple device. So that's why things goes on. This is the difference between a common person and a commercial person. So this is the data which I have shared with you. These are the list of the top 10 institutes with the number of application filing. Okay. Now these are the certain intellectual property types. First one is patents. After that is design, trademark, geographical indication, semiconductor, integrated circuit layout design, and copyright. So first of all, what is patent? So patent is given for the inventions only. Okay, what is inventions? Invention means there should be some technical features. There should be some technical advancement over the present available technology. If you have any certain technical improvement over the present technology, then you can file a patent for that. Okay. Design registration can be filed for the article, not a software article. It must be a hardware article. Okay. It may be 2-dimensional or 3-dimensional. Trademark will be given for any trade name, trade symbol, logo. We will see in the further slides. We have to look each one by one. Geographical indication. Geographical indication is not given to a single person. It is given to a community. Suppose that Darjeeling tea indicates the people residing in that community, residing in Darjeeling. So Darjeeling tea does not indicate any individual. So all the except geographical indication, all the intellectual property can be filed by an individual, but geographical indication can be filed only by a community. So if there is any unique, any new thing, any original thing in your community, you can file a geographical indication for that. Okay. And after that, semiconductor integrated circuit layout design is also there. So nowadays everybody needs faster speed in the mobile, more data storage, more safety features, and all this can be possible with semiconductor devices only, or it design layout. Okay. And last but not copyright. So copyright is something. Suppose that you have just written a poem, just you have completed right now. So you have from that time only you have the all complete right on from that. You don't have to go to the copyright office. It's, for the copyright protection. So you have just completed it. You have the copyright from that. You have the copyright from that time only. Suppose that you have your institute have your prospectus, your brochure. You are going to release each and every year. So from that time only, nobody can copy your brochure or your information brochure, or your other institute cannot copy that. So just you have finishing it from that time, you have the complete right on it. Okay, you need not to go to the copyright office. So this is not an exhaustive list. There is anything which is a creation of mind that belongs to intellectual property. Most of the person have taken, or they are going to take the degrees that are also an intellectual property. Okay. So different IPs. See, this is a single product, but a multiple intellectual properties. Thing is that you cannot bound yourself that you have invented a certain type of a specific type of pen with a certain technology. So so that you can file so many patents for that. If you are filing patent, you can also file for the design also, trademark also, copyright also. We will see with this example. This is an Apple laptop, and in which the LED display has a technical feature, so you can file a patent for that. This is the body of unique and new design of body of laptop. For this you can file a design. Okay. For Apple sign, you can file a trademark. And user manual, since when you move into any electronic shop, they will give you the user manual how to operate this. Since that manual has been created by this company only, so they have the complete right over it. Okay. So they can file copyright for that, and every laptop has his circuit design, SICL design, so he can also file SICL design also. Now what is patent? Patent is a grant given by sovereign or state to a person for giving exclusive right to stop others from 5 things. You can stop others from 5 things: making, using, exercising, vending, and importing. Means uh, you only exist out of 140 crores of people when you will get an exclusive right, when you will get a patent right. So you only exist, nobody can exist. You can stop anybody from 5 things. You can stop him from making, using, exercising, vending, and importing. Okay. The thing is that it is a territorial right. Territorial right means if you file your application in India and somebody is commercially exploiting your invention in Bangladesh, in Pakistan, in Sri Lanka, in Japan, you cannot stop him. For stopping your invention in that country, you have to file your application there also. So it is a territorial right. Okay. And invention is given for a limited period of time. Patent is given for 20 years of time only. So after 20 years of time, your technology will become a public property. So in your room also, you are seeing the ceiling fan, ACs, the call bell, the doorbell, all are very all in the inventions has been passed 20 years time has been passed. Now it has become the public property. Anybody can, by reading that document, can by reading that document, anybody can make that invention. Okay, and these benefits government is giving to the inventor or the patentee. So since government works for the public, so what the public is going to get in exchange? So in exchange of that, the patentee or the inventor has to disclose his invention, how you have made that invention, how you have done that invention. Okay, you have to disclose the best method known to the inventor. Okay, so suppose for example, Thomas Alva Edison has invented a bulb. So after making invention, he filed patent for that, and he disclosed his invention, that how bulb can be made. So the person who are working on that field, he has to not do start with the scratch. Okay, he has now certain information. उसके पास कुछ information आ गई है कि बल्ब को कैसे बनाया जा सकता है. अब उसमें वो इम्प्रूवमेंट कर सकता है, टेक्निकल एडवांसमेंट कर सकता है. So that is the benefit of disclosing of exchanging of, for the disclosure in a patent. So it is also a technology exchange program, patenting system. Okay. So these are the small patents. Okay. This is a trampoline. Now it is used in the Olympic. This is siphon effect. When you will press the cup, after that liquid will come out of it. This is stubby gloves for holding. Okay. These are the famous foreign inventors. These are their inventions, and they have earned millions and millions of dollars. You have also heard the name of the inventor of the steam engine, James Watt, and he was the richest person at his time. Okay. So now these are the famous other Indian inventors: nano car technology, hepatitis vaccine, Jaipur food. So you can make so they have earned millions and millions of dollars by these inventions. They have made this invention. They have started exporting outside. Okay, this hepatitis vaccine, after completion of 20 years, the person anybody can make it who has the knowledge of by reading that document. Anybody can make this. So simply by this process, this vaccine will become cheaper. It will become a lesser cost. Okay. Now patent filing. This is the patent filing system. Since you know that patent is a territorial right. Since it is a territorial right, so you can and you want to file your application in United States. Okay, you have filed your application in India, and you want that you can file your application in Europe and United States. So how it can be done? So there are two methods in which you can enter into the arena of different territory. First one is PCT, and another one is convention. So PCT means Patent Corporation Treaty. So the countries who has filed Patent Corporation Treaty, all the countries, you can enter into that countries within 31 months of the time. Suppose you have chosen India as a ISA in the PCT filing. So you can enter any of the country within 31 months of the time. You have the priority of 31 month. You have the privilege of 31 month. Okay. In case of convention or Paris Convention, so the countries who have signed the Paris Convention. So if you have filed your application in India, so you can move into that country within 12 months of the time. You have the time. You can think that in which countries my technology will have more commercial value. You can file your patent there. Okay, and it is the 12 months from the date of earliest priority. Okay. And it is also applicable. Suppose that some US applicant is there, he has filed an application in United States. He can also choose the convention route, and he can file his within 12 months. He can file his application in India also. Okay. Third one is ordinary route. Ordinary is for the Indian resident only. and in which you can file a provisional specification. Suppose you think that your work is going to complete within 12 months of the time, and so in that case you can file your today you can file your provisional specification, and within 12 months of the time you can file your complete specification. Okay, so after filing complete specification, it will be published within 18 months of the time. After publication, you will get the first examination report, and within 6 plus 3 9 months of the time you can file your reply, and after filing reply, if all objection met, you will get the grant. Otherwise you will have to face the hearing and disposals. Okay, if the objection is again not met, you will get the hearing, and all objection met, it will be granted. Otherwise it will not be granted. These are the minimum forms to file a patent. Form 1, in which each and every details of the application and applicant has to be disclosed. Form 2 is there, in which details of the invention, title, background of the invention, particular of drawings, brief description of drawing, brief description of the invention, claims, abstract. Drawing, you have to give the full details. Since patent is given for the claims only, okay? So what you are claiming, suppose that you want to claim a thermoflask, and you want to say that the previously existing thermoflask is heating the water, is keeping the water warm for 10 years. Now your device is going to give the same quality of water for the 20 years. So you are improving the quality of the thermoflask. You are improving the isolation, insulation, better insulation by using better material. So you have to disclose all these features into the claims, and all others are the supportive to that form 2. Okay, now after that, form 3 is there for details of foreign filing of similar invention. Okay, for this fees are not required. Form 5 is again there for the declaration as to inventorship, in which you have to declare that you are not the applicant will declare that I am not the inventor, and these are the name of the inventor. Okay, Form 18 is there. When you will file Form 18, after that your application will go for the examination. Before Form 18, it cannot be moved further. These are the fees. Form 1 fees is 1600 for a natural person. Form 18 fees is 4000. The total fees is 56,000. 5600, sorry, not 56,000. So this is the minimum amount in which you can file your patent. Okay, for the natural person. For the company, 8,000 fees is for the Form 1, and 20,000 for the Form 18. So 28,000 is for the other than company. Now institutes fees has been reduced for the institutes. So 80% reduction is there. Okay. So now these are the filing process. This is the online filing process, and through online you can file your application. While clicking, this page will open, and you have to make a registration. After registration, you will get the each and every details here, and you have to file. Guideline is also there provided. Okay. Now there is expedited examination also, means suppose that office works on the principle of first come first serve. So if you want that your application should be expedited early, examined early, and so office has given certain provision. If you are a startup, if you are a small entity, if applicant is a female, okay, or joint applicant, suppose that there are 4 individuals, and out of 4 applicant, if there is 1 female, then it can be expedited. And for the department of the government and other government establishments, if you have chosen India as a ISA in IPA in PCT filing, if there is any agreement between Indian Patent Office and Foreign Patent Office, in that case, all these cases, expedited application can be filed. Now patent application processing, first it will get examined. After that you will get the first examination report, and after that reply will be filed by the applicant, and if objection will persist, hearing will be conducted, and in hearing it will be either grant or it can be refused also. So important chapters of patent. So thing is that everything depends on your drafting. How you better you draft your invention. So that is why drafting can be how it can be done. It is disclosed in chapter 5 of Indian Patent Manual. When you will search in the Google Indian Patent Manual chapter 5, you will a PDF will be open. It is available free of cost. So you can see how the patent can be filed manually. Now every complete specification shall be fully and particularly describe the invention. This is the first point under section 10.4. It is very important section. Section 10 completely disclose how you can file your how to draft your invention. Okay, you have to disclose the best method known to the inventor. You have to define the scope of the invention from the first day. Okay, you cannot change your scope of the invention. If you are a claiming pen, you have to be strict on it. Tomorrow you cannot say that pen and pencil both. So you have to define the scope of the invention from the first day. All things are, you can read it. It is very written in understandable manner. It is not to be very written in a very simple manner. Okay. So other thing is that this is a technical examination for your invention. So for invention, it will be checked for the novelty and inventive step with respect to the citations. Okay, and on the basis of detailed report will be prepared. So this is a pencil. Okay. So if a pencil is made of a core is made of a graphite and the cross section is made of a polygonal cross section. So the office has come with an prior art. Prior art means which is known before the filing of your invention. जैसे आज आपने अपना एप्लीकेशन फाइल किया तो आज फाइल करने से पहले जितने भी डॉक्यूमेंट होंगे जो पब्लिक में नोन होंगे वो इंडियन हो नॉन इंडियन हो पूरे यूनिवर्स में सर्च होगा यूनिवर्सल सर्च. सो प्रायर आर्ट कहीं पर भी अवेलेबल होगा. जो ये डिस्क्लोज कर रहा होगा इट इज अ पेंसिल and which is made of a graphite and having a wooden casing which has a hexagonal cross section. So यहाँ पे polygonal cross section है, यहाँ पे hexagonal cross section है. तो ये assume किया जाएगा कि जो person hexagonal cross section बना सकता है he can also make a polygonal cross section. So it will be assumed that this application, this invention has no novelty. Okay, and novelty के लिए सिर्फ एक ही document चाहिए. Only single document is required. Coming to the inventive step, there are two documents. For inventive step, minimum 2 documents are required. Okay. First document is a pencil comprising a core made of graphite and clay and a casing of wood. First one is disclosing a pencil. Second document is disclosing a pen with a cross section having hexagonal. So by the combination of these two documents, a person skilled in the art can reach to the present invention. Now these are the basic timelines. Provisional to complete specification 12 months time. Request for examination 48 months. Reply to FER 6 months. Form 3 6 month time. Form 5 1 month. Withdrawal of application 15 months. Hearing submission can be filed with 15 days. Pre-grant opposition can be filed before the grant of the application. And pre-grant opposition can be filed by any person. But post-grant opposition can be filed the person interested who has the knowledge in that field, he can only file the post-grant opposition. And it can be filed within 1 year after the publication of the granted patent. Now, after that, design is there. Design is governed by the Design Act 2000, Design Rule 2001, and Design Amendment Rules 2021. This is the latest amendments. And design means only the features of the shape, configuration, pattern, ornament, or composition of lines or colors. Thing is that design only judged, office only going to judge by looking solely by the eyes. Okay? हमें आंख से देख के सिर्फ पता लगाना है और हमारे पास कोई टूल नहीं होता है डिजाइन को जज करने का. और फर्स्ट थिंग, सेकंड थिंग, द आर्टिकल शुड बी फिनिश्ड. इट शुड बी अ फिनिश्ड आर्टिकल. सेमी फिनिश्ड आर्टिकल ये नहीं चलेगा. सेकंड थिंग, आप कोई नेचुरल चीज लेके आ गए तो कंप्लीटली नेचुरल हो तो उसका भी डिजाइन आपको नहीं मिलेगा, उसमें कुछ ना कुछ पार्शियल आर्टिफिशियल डिजाइन होना चाहिए, कुछ ना कुछ आर्टिफिशियल स्ट्रक्चर होना चाहिए, या तो वो पार्शियल आर्टिफिशियल हो या वो 100% आर्टिफिशियल हो. ओके, so these are the certain criteria of the design application. Now the thing is that suppose that there are two types of product, both are have same inventions, both are same inventiveness. So but one person is smart, he is making good design of that, so उसका अच्छा design बना देगा एक inventor. So of course any person will move to that product, that this is a good design, so I need that design. So डिज़ाइन का ये मतलब होता है, अगर कोई प्रोडक्ट है उसका अच्छा डिज़ाइन है, so that sometimes it become the unique selling point. Okay, and terms of design is 10 years, it can be extendable up to 15 years, 5 years more. Now these are the design of an article. This is sofa set, this is a watch, all are, you know, all these are unique design. All this industry works on the design principle only. Nowadays you can see mask, different types of masks. This is bicycle. Okay, now this is the design of set of articles, different articles, set of articles. These again completely depend on the design aspects. Now what are the requirements? These are the fees, minimum fees which you have to file. Application fees 1000 for the individual, application form 1, in which applicant's full name, nationality, legal status, address for service in India, class number, name of article, priority date, prior registration data, signature and date, everything you have to return, give in the form 1. Okay, you have to disclose the power of attorney if required under form 21. Assignment document you have to give, if any you have. Form 24, if you are a small entity or a startup, and you have to also give the documentary evidence with respect to form 24. Okay, this is a teapot which has recently got the design registration. This is again a drone technology. This has also get recently designed technology. In the similar manner, you have filed the first examination report for the in the patent. First examination report you will also receive in the design, and you have to file within 6 months from the date of filing. And 3 months extension you can take. Terms is 10 years, and it can be extendable up to another 5 years. Condition is that you have to give the renewal fees 10 years. Within 5 years, each and every year you have to give the renewal fees. Otherwise, your intellectual property or design registration will not be in force. Now come to the trademark. Trademark is given for the any trademarks, trade name, collective marks, certification marks, taglines, slogans, shapes, sound marks. Okay, you have seen when you will open your window, computer window, you have heard a particular type of sound. In the Kaun Banega Crorepati, there is also a particular type of sound. In IPL match, there is also a particular type of sound. So these are the sound marks for which one can file a trademark also for a unique sound. And it is also possible that one company may have more than one trademark. It may be a word, it may be a website name, it may be a slogan, it may be a symbol, it may be a word, it may be certain logo, bottle design can also be trademark. The thing is that it should not be descriptive. By looking from the eyes, just from the eyes, anybody can understand that, okay, this is the logo of this trademark. And how to indicate your trademark? So there are generally two logos you have seen. When it is written with R with a circle, it means trademark has been registered, and TM means it has not been registered, it is unregistered, and application is still pending. So it is very good for the trademark. So it must be honestly adopted, and no similar all should be exist in the market. You have to make a honestly search so that unnecessary litigation can be avoided. Okay. So how to protect? So for the protection, few things you have to keep in mind. Trademark registration is optional. It is not compulsory to get the trademark. But the benefit is that when you will file for the trademark, office will stop the similar logo and the trademark symbol. Okay, your authenticity, your product will be genuine, and when it will get published, you will get the national, regional, sorry, and international recognition, because after publication anybody can see this. Okay, and anybody can make licensing with you. And existing trademark registration is governed by the trademark in 1999 and trademark in 2017. Okay. Now come to the copyright. Copyright can be given for the ideas only. Okay. There should be much creativeness, originality, fixation. Okay. So these are the subject matter of copyright. It may be certain literary work, it may be certain artistic work, it may be certain dramatic work, musical work, sound recording system, cinematography, something. As I told you, when you wrote any poem, so from that time only you have the complete right on that, and it is a universal right. It's patent is a territorial right. It's not a territorial right. It is universal right. And it is governed by the Paris Berne Convention. So the whole country who has signed the Berne Convention, he has the complete territorial right on it. Okay, he has the complete universal right on it. And the term line, you can see the term line is very, very important. If you have any good book, so you will get the royalty up to your life, plus up to 60 years. After the 60 years also, his next generation, he will also get benefit. If he has a good literary work, dramatic work, artistic and musical work. Okay, these are the fees: 500 for the literary work, artistic work 2000, sound recording 2000, cinematography it is 5000. Now come to the SICL design, semiconductor integrated circuit layout design. These are the forms, form number LD1, LD2, LD3, LD4, LD6 and up to LD33. These are the similar different types of forms. Out of these forms, LD1 is the compulsory form which you have to file. And in which form 1 you have to disclose this is the display, this is the design lookout of the semiconductor integrated circuit. When you will submit this, so after submission, the registrar will find if there will be any issue, registrar will refuse it. Otherwise, he will accept it and put for the advertisement, and he will wait for the 3 months for the opposition to come. If no opposition will come, it will be granted, and if opposition will come, it will be gone for the hearing, and in hearing all objection met, it will be granted, and on the basis of the evidence provided by the opposition, further proceeding will be done. Okay, now in India, very less number of filings has been done in the field of SICLD. Only I think less than 10 application would be there. Now coming to the geographical indication, as I told you, it is given to a community only, not to an individual person. So a geographical indication is an indication that identifies a product that have a specific geographical origin. Okay, it should have a specific origin and possesses quality or a reputation that are due to that origin. So it has all the qualities due to that origin. So Darjeeling tea, it must have all the quality due to that origin, due to that reputation. Okay. So these are the few examples. Darjeeling tea, it reflects the community of the Darjeeling. Makrana marble, it shows the person of the Makrana in Rajasthan. Ratlami seb, it belongs to the Ratlami people in Madhya Pradesh. Kachipuram silk in the Tamil Nadu. Kashmir saffron, Shahi lychee of the Bihar. Maghi pan, Kurg orange from the Nagpur. Okay, all these are examples of the geographical indications. Now this is very important. There are certain points to be remembered. First of all is that first protect your invention, then publish it. Means suppose that what the common inventor do, they used to publish their paper. After publication, they file for the patent application. So when they will file for the patent application, that published document will become the novelty destroyer. He will destroy the novelty. He will destroy the that application, because thing is that it will not be novel. All the what I told you, आपके publication से पहले वो public domain में नहीं होना चाहिए, और जब आप उसको publish करिएगा तो वो public domain में automatic आ जाएगा, तो आप उसको protect नहीं कर पाइएगा उस application को. Okay. So first thing is that. Second thing is that the rights are territorial in nature. If you have filed in application in India, you will get all benefit in India. You cannot benefit in other countries, and registration is done by the sovereign authorities only, by the government of India only. Nobody other state government can give you the authority, and rights are given for the limited period of time, and no automatic relief. You have to file infringement in the case of violation of your intellectual property. Renewal fees you have to pay time to time, and appointment of patent agent is not compulsorily. Okay, if you have sound knowledge, then you can file your document himself or herself. These are the government initiatives: expedite examination, reduction in fees for the education startups. Okay, and these are the career opportunities. And first one is the government job. If you are a engineering graduate or science postgraduate, you can become an examiner of patents and design. If you are a law graduate, you can become a trademark and geographical indication and copyright examiner. All these are gazetted officer post. Okay, you have other option also. If you can also become, if you are a science graduate, you can also become a patent agent. If you have a law graduate degree, you can become a trademark agent. JRF, SRF, you can take part in patent facilitation center. You can work with IPR firm. You can also take part in patent litigation and other opportunities in private sectors. Okay, so these all are the careers with the IPR, intellectual property rights. And this is our institute details. You can contact here. We have also Facebook and Twitter account. And I request to the coordinator also, if you have taken any pictures, please share with me, because we will upload it on the Facebook and the Twitter. And
Surely, sir.
okay, ma'am. And this is the details. If you need any further information, you can put your suggestion and your question also in Twitter and Facebook. And this is the online program, which offline program, which of RGNA APM is going to be conducted from 22 to 26 of the August. If anybody interested, he can register here, and the fee structure is 2,000 per day per participants. Minimum 2 days registration is required, and there is 50% concession also for student lady participant, honorary employees of the startup or SMEs, MSMEs, or 4 or more participants from one organization, officers from college institutes. Okay, and it is related with the patent specification, case studies, all these things. So thank you. And if you have any question, I request you to please ask your question.
Thank you, sir. The questions from the audience are welcome, and you can post your queries in the chat box provided. Manju Dubey has raised her hand. Ma'am, what is your question, please? If you could please write the question in the chat box. Questions are welcome from all the attendees.
He can also ask by unmuting himself or herself. He can also ask if you feel difficulty in putting in the chat box.
Sir, I have one question.
Yes, yes.
Few days ago, I was reading about patents of SpaceX, which is the one of the renowned companies started by Elon Musk, and he has a goal to establish colonies in Mars by 2050. That company has recently invented reusable rockets, and I was searching about patents and concerning their reusable uh, spacecrafts. Uh, that company has no patents. And what Elon Musk has said that we don't intend to have patents in this domain since the Chinese companies will use our documents as a recipe book, and these statements even hold till 2021. So my question is that how the privacy aspect of the inventions are been have been taken care of by the laws, uh, by the
See,
existing laws.
see, two things are there. When you file your application to since there is only limited offices in every country, when you file your application, so there is automatically non-disclosure agreement. Nobody can see your application before publication, even the office. He cannot look your application before publication. Anybody will look your application after publication only. And when it will get published, since it is universal publication, anybody can look your application after publication. So there is non-disclosure agreement. If you think that if certain application has been in the public domain before your publication, so you can complain, or you can put your query to that office, and he will take care of that. Or since now we didn't see any issue that everything has been come in the public domain after a publication only. Okay.
That application will be open to a public for 20 years or after 20 years, completion of that 20 years.
It will be open for public since for the Indian domain, I am saying that when you have filed your application, okay.
Yes,
So
sir.
after 18 months of the time, it will be
Okay.
published.
Okay, sir.
In 18 months of the time, it will be published. So from 18 months of the time, why it is required to get published? When it will be get published after publication, suppose that some person is also working in that field, as you told about the Elon Musk and the Chinese company, and a reusable rocket. Again, same example, I have given certain patent. I need protection for the reusable rocket. Office will get the publication, and after publication, anybody can file the pre-grant opposition. So for filing opposition, publication is must. Okay, first thing. Second thing, you are also working in on the same field on which I have filed the patent. So when you will read my application, you will understand that